Hi, good morning. Very good to see all of you for another exciting discussion about equal pay. It's been a very hot topic in recent years, and we've had other presentations on different aspects of it. And happy to see you at a discussion this morning of the Equal Pay Act and Colorado's new equal pay statute, which will be eye-opening, I think, and certainly pose some challenges for employers. My name is Brooke Khaleesi. I know many of you, some of you I do not. Very happy to see you. Need to go through a few logistics before we get started. For those attending by webinar, if you get disconnected, use the link that you used to connect initially to reconnect to the webinar. Hopefully that will get you back on track. Please ask questions. Please make comments. Anything you have to say, your experiences, your concerns are every bit as informative as anything I'm going to tell you this morning. So by all means, please jump in. We'll also try to have some time at the end for some questions, and I'm happy to hang around for a few minutes after as well, if you'd like to discuss anything privately. Finally, we are recording today's program, and we'll circulate an email and follow up with a copy of the audio recording and the PowerPoint. Feel free to share, feel free to use it as a resource, feel free to reach out to those of us in the department if you have follow-up questions or concerns, and of course, we're always happy to help with all of those. Let's talk about pay equity. Some of you may have had the opportunity to attend Bill Wright's presentation a few weeks ago about EEO-1 pay data. Pay equity, pay data, the whole notion of discrimination and compensation has been a very big issue for many years now, and certainly in the last few years really come to the forefront, and especially in Colorado, where we've seen now in the last year a political climate that really allowed for the passage of new legislation in the employment arena, and a lot of it very employee-friendly, if you want to put a tag on it. So we have some new things we need to consider as employers, and a new equal pay statute is one of those things. So I think what I'd like to do today is walk through, as a refresher, the requirements of the Federal Equal Pay Act, which has been around for many years. Many of us are very familiar with that. But it's a good contrast to the new Colorado law. And it's very important, obviously, that you understand the distinctions between the federal law and the state law, so that you understand what you might need to do within your organizations to adjust. And certainly if you happen to have employees across multiple jurisdictions, the distinctions are going to be very important. So that's what we're going to do this morning. As I said before, by all means, please jump in at any point in time if you've got questions or comments or scenarios, and we're happy to talk through those as well. So with respect to the Federal Equal Pay Act, it's a very old statute. It came out of a big push for wage equalization following World War II, where we had a huge influx of women into the workforce because all the men were off fighting. But it didn't actually get passed until 1963. So the Equal Pay Act actually predates Title VII. And it is part of the Fair Labor Standards Act. It is not part of Title VII. It is part of the minimum wage overtime statute that we're all very familiar with. And the white-collar exemptions that we're used to with respect to minimum wage questions, overtime questions, and the like were actually excluded from the original statute and put back in 1972. So since 1972, we've been dealing with an Equal Pay Act that covers individuals in all types of roles within an organization. So what is the Equal Pay Act? What does it protect? What does it dictate? It requires that there be equal pay for equal work on jobs, the performance of which requires equal skill, effort, and responsibility, and which are performed under similar working conditions. It applies to all forms of compensation. We tend to focus on wages or salaries, but it goes far beyond that. If you have other components to your compensation structures, the tenets of the Equal Pay Act will apply to that as well. So you need to make sure that the equality extends across the entirety of your compensation scheme. And as we're often familiar with, the focus really here is on the content of the job, not titles. Titles only get you so far. And it's very important that, you may have had an organization where you've had people within certain roles with certain titles for many number of years, and it's very important to look beyond that and really look at the content and the actual duties that those individuals are performing, because that's what's going to matter in determining whether or not you have a situation under the Equal Pay Act that you need to get adjusted. So the Equal Pay Act prohibits discrimination in compensation on the basis of sex. So here we go again. I don't know if any of you were able to attend some of our presentations in the spring where we talked about the evolving definition of sex in federal employment law. Same issue applies here with the Equal Pay Act. It's the same language that's in Title VII on the basis of sex or because of sex. And as you may know, we have a huge dispute within the courts about what that means. Traditionally, it meant a binary definition of sex, male versus female. And the controlling case in the 10th Circuit that covers Colorado is still a case that adopts a binary view of sex, male versus female. The risk there is that a great many courts, including in federal agencies as well, including the EEOC, have for the last several years taken the position that that's not what sex means, and it's much broader than that. That it covers gender identity, it covers sexual orientation, it covers transvestite type status, those types of things. So we are still in limbo with respect to what on the basis of sex means, and you need to be cautious, just as you are with respect to Title VII, in taking too narrow a view of sex. Even though we have a case here in Colorado that keeps it reined into what the original understanding was, the chances of that case, being overturned, frankly, are pretty good, one way or the other in the next few years. So keep that in mind as you're making some of these determinations. Interestingly, if you ever turn to the EEOC guidance on the Equal Pay Act, it still refers to compensation differences between men and women, which probably is merely a function of them not having the budget or the staff to update their guidance. I can pretty much assure you that the EEOC does not take a position. Who's ever on the phone? Could you please mute your line?
Something outsourced center. They said, they're still our.
Whoever's on the phone, could you please mute your line?
They would handle all the payroll processing, and we didn't have to do it.
So sorry, everyone.
And I asked her, I said, do you have something like in the U.S. they have what's called ADP Total Source, where it's a true.
Thanks. No problem. So the EEOC administers the Equal Pay Act, even though it's part of the FLSA. So you can pretty much rest assured that if you have an Equal Pay Act dispute, the EEOC is going to take its traditional view of what sex means and looking at the statute. So it's something to keep in mind as you're going through these issues within your workplace. And no, I'm not looking.
Touch the screen real quick and I'll.
I didn't do it, I swear.
While I'm muting,
Good?
Okay, there we go.
Okay, thanks. So with respect to the application of the Equal Pay Act, the jobs do not need to be identical. They only need to be substantially equal, which obviously builds in some discretion, right, in your evaluation of whether or not jobs are equal or not for purposes of compensation. And then there are exceptions to the equal pay for equal work. So these are the scenarios under which you are allowed to have a wage differential under the Equal Pay Act. You have a seniority system. So obviously if you have two people in the same job, but one of them's been there 10 years and one of them's been there 5 years, you can pay the 10-year employee more than the 5-year employee because they have more seniority. A merit system. Now merit systems are also inherently subjective, right? So there's some subjectivity built into those criteria, but you can apply a merit system to compensation where higher performers get better pay. A system that measures earnings by quantity or quality of production, so some sort of piece rate issue where how many units somebody produces within a given shift helps determine what they make, for example, is allowed under the Equal Pay Act. And then this is the kicker, any differential based on any other factor other than sex. So basically it's a catch-all. And if you have any legitimate non-discriminatory reason for a wage differential under the Federal Equal Pay Act, that wage differential is fine, and you can proceed with that. That's big, and we're going to talk about that here in a few minutes because it is absent from the Colorado law. And here's something that we often don't talk about. If you find a discrepancy among jobs that you believe are substantially equal, you are not allowed to lower anyone's pay in order to make that differential go away. So if you have an employee who's being paid more, you have an employee who's being paid less, and you realize that that employee who's being paid less really is doing the same job as that other employee, you have to raise that employee's salary rather than reducing the salary or the wages of the higher earning employee. So it's really a focus on trying to push wages up and salaries up rather than pushing them down to reach any kind of equality that way. So what does substantially equal mean? As you're evaluating the jobs within your organization, trying to determine which jobs you need to compare, to determine whether or not you have any kind of pay discrepancies that need to be addressed. Skill, effort, responsibility, working conditions, and establishment are the criteria under the Federal Equal Pay Act. Skill, pretty, standard definitions: experience, ability, education, and training. And it's important to realize that with respect to these items, they're looking at what is required for the job, not what the individual has. So if you have an individual who has just enormous experience or education, but that experience or education is not really pertinent to the actual job that's being performed, you're not really going to be able to rely on that in order to justify a higher pay rate or pay wage for that individual, if that makes sense. So you really need to focus on what is required for the actual job that's being performed. Effort, physical and mental exertion, obviously are relevant. Responsibility, the degree of accountability, minor differences don't count. That's a pretty typical thing when we're looking at these kind of employment laws. You really have to look at what the accountability is on a broad scale and the responsibility on a broad scale. Working conditions, physical surroundings, temperatures, fumes, hazards, those kinds of things. Obviously came out of a different era where we tended to have more industry and manufacturing type work, but still a factor that can be considered today with respect to discrepancies. And then this last one is very important too for comparing this law with the Colorado law that we're going to talk about here in a few minutes, the notion of an establishment. So the Equal Pay Act applies to employees performing substantially equal jobs in the same establishment. So that means the same building. It may mean the same campus if you have a facility that's got multiple buildings on a single site. There's a little bit of leeway there with respect to what that means, but on the whole, it tends to focus on a single location of employment. And it's that arena in which you're looking to determine whether or not you have any impermissible wage discrepancies. So that's really important, and it helps, kind of rein in the analysis that you need to do under the federal statute. So under the Equal Pay Act, these remedies mirror the FLSA. As I mentioned before, the Equal Pay Act is part of the FLSA, not Title VII, so we have FLSA type remedies available. Back pay, liquidated damages, which are usually an amount equal to the amount of back pay that goes to the employee. And then, of course, attorney's fees and costs, big, huge gorilla in any case. They can get their attorney's fees and costs for any violations of the Equal Pay Act. So there are no compensatory and no punitive damages available under the Equal Pay Act, and that's because it is part of the FLSA. So there's no emotional distress. That's typically what compensatory damages are in the employment arena. And then the punishment damages, liquidated damages to some extent, they feel like punishment type damages. Legally, they're characterized a little bit differently. But with respect to the punitive damages that we often see in discrimination cases, for example, those are not available for a violation of the Equal Pay Act. But it's something to keep in mind because Title VII also addresses terms and conditions of employment and also prohibits discrimination on the basis of sex. If you have a violation of the EPA, as long as you have the jurisdictional requirements being met for a Title VII case, you probably have a per se violation of Title VII as well. And we're going to talk a little bit more here in a little bit about the EPA versus Title VII, how they kind of interact, and when you may see one claim brought as opposed to the other, and so forth. So keep in mind, just because you have something coming at you under the context of the EPA, be mindful that the Title VII statute is out there as well that could cover the same conduct. So let's talk a little bit about the new Colorado statute, and my colleague Joe Hunt is here as well. He did some work with this in the context of his work with the CBA, so Joe, jump in if you've got anything to share. I did a little bit of work on this with the Colorado Chamber of Commerce, trying to address this from a business perspective. What are the business issues? What are the employer issues that come up in the context of these statutes? Which is always a very interesting position to take because you're essentially fighting a bill that is trying to equalize pay between men and women, and I don't think any of us would disagree that equalizing pay between men and women is a good thing. But the whole point is trying to find legislation that works for business and works for employers, and so that's always the challenge. And so I want to talk about specifically the areas where it could be problematic for employers in trying to implement this bill now that it has become law. So with respect to the Colorado statute, kind of the overarching theme that we heard from the proponents of this bill is that the Federal Equal Pay Act isn't working, that there's still a huge disparity between men and women and also between minorities and non-minorities with respect to wages. And so the theory is that we need something stronger, something with more teeth to try to address this issue of wage disparity. So with respect to the legislative declaration, these are some of the statistics that were put forth in support of the Colorado bill. That women earn just 86 cents on the dollar compared to men. That Latina women earn 53.5 cents on the dollar compared to white men. and Black women earn 63.1 cents on the dollar compared to white men. So these are the kinds of statistics that are really driving these wage equalization statutes, and they're not just in Colorado, they're all over the country. So under the Colorado law, sex means gender identity. So we do not have the somewhat uncertain situation that we have under federal law. For many years, Colorado has had a much more expansive definition of sex to include gender identity, transgender status, sexual orientation, and all of those different situations are going to be covered under the Colorado statute. Gender identity under Colorado law means an individual's perception, and it is not restricted to the binary male-female view of sex. Now, one practical issue with this broader definition is that gender identity is, as it indicates, a perception. And it may or may not be something that is obvious to you as an employer, right? So you could potentially be facing situations where you have employees who are concerned about there being wage differentials based on, for example, gender identity, and you're going to be struggling with, what was the knowledge of gender identity? Do we know what someone's gender identity is? In some cases you might, in some cases you might not. So it creates a little bit of a difficult situation for employers in attempting primarily to address complaints of wage disparity under the Colorado law. The law also specifically prohibits discrimination based on sex or sex plus. Sex plus some other characteristics, sex plus race, sex plus religion. Any other protected status under the law can be wrapped up into the statute if it's combined with sex for purposes of a claim for violation of the Colorado statute. So under the Colorado law, we have substantially similar work based on a composite of skill, effort, which may include shift work and responsibility. So you may recall skill, effort, responsibility from the Federal Equal Pay Act. Those are terms that are used there as well. It's also notable that the EPA also included working conditions, as we saw, and it included the definition of an establishment, or the concept of an establishment. So under the Colorado statute, we do not have that establishment restriction, right? We do not have this notion that when you're looking at jobs and determining whether they're substantially similar, that you're looking at them in the context of a single unit or a single building or a single work site or a single campus. And that raises some interesting questions as to exactly how this statute is going to be applied. What if you have employees in Colorado and you have employees in California? Are you required under the statute to consider everybody performing similar work in all of those locations? I think we can say with some confidence that the Colorado law is not necessarily going to apply to those California employees, but the situations of those California employees, what they're doing, what their wages are, what the wage disparities are, could very well be part of the analysis that you need to do in determining whether or not you're complying with the Colorado law. We just don't know. The statute is not specific on that point. We're hoping that some regulatory guidance will be forthcoming from the Colorado Department of Labor that will help clarify exactly what it is you're looking at. So because we don't have that establishment concept, it's very possible that you're going to have to look across your organization, both within the state and even out of state, to consider whether or not you have impermissible wage disparities in Colorado. So we'll have to see. Hopefully we'll get some guidance on that. There's no guarantee that we will, so we're just going to have to wait and see what happens with respect to that. So under the Colorado law, to sustain a wage differential, you have to satisfy each one of the following, you must satisfy each of the following. So these are the exceptions. These are the situations in which you're allowed to have a wage disparity among individuals in similar working positions. So we have seniority system, merit system, the quantity and quality of production. We saw those under the Equal Pay Act. There isn't any additional exemplification of those items in the statute. So generally we can assume that they're going to probably have the same meaning as they do under federal law. Colorado does tend to defer to federal law with respect to similar concepts unless, for some reason the statute has expounded on them or the Department of Labor has expounded on them. So those are probably going to mean what we're used to having them mean under the Equal Pay Act. We also have the notion of geographic location where the work is performed, the education, training, and experience, and travel added to the considerations that you can have into whether or not a wage differential is appropriate. Now, these concepts of location, the concept of travel, the concept of training, we saw those under the Equal Pay Act, but we saw them in consideration of whether or not the jobs were substantially similar. Under the Colorado statute, they are not in that consideration. They are part of the consideration as to whether a wage differential is appropriate. So what is the practical effect of that? The practical effect of that, I think, is that your analysis gets pushed back into the process, right? You're going to be focusing more on the justifications for a specific wage differential, and you're not going to be able to stop your analysis simply at looking at the job, because you're going to have all of these things that you can look at under the Equal Pay Act to determine whether you even need to look at those jobs together, are going to be pushed back until this analysis of whether or not a wage differential is appropriate. And I think that's probably pretty deliberate. There's been a trend to try to force employers to focus on the big issue of the actual distinction rather than trying to get out of the analysis by cutting it off early and saying, hey, those jobs aren't even similar, so we don't even have to consider the situation. I think the intent of the statute is to get you past that hurdle and having to really focus on whether the wage differential itself is appropriate. So under the Colorado statute, each of these has to be applied reasonably. What does that mean? Who knows? Courts probably will tell us 10 to 15 years down the road. We might get some guidance from the Department of Labor, but obviously that's going to be a very subjective standard. And so you have to use caution when applying these factors so that you can have good justification for the application of the factors. And here's one that honestly I don't know if this is poor drafting. I don't know if it's some meaning that's just not obvious when you read the statute. But each factor relied on has to account for the entire wage differential. Now, I don't know what that means. Does that mean that everything you're relying on has to account for the whole differential? Does that mean if you have 3 of these factors that apply, each one has to account for the wage differential? I don't know what that means. I don't know if the Department of Labor knows what that means. Hopefully we'll get some clarity on that. So it's just hard to say at this point exactly how you're going to have to approach applying these factors to the wage differential. Needless to say, you're going to have to have some very specific analysis of how each of these applies, and the more information and the more detail that you can put together in your files in terms of why people in certain jobs are being paid certain amounts is going to be very important. And then finally, the wage rate history is not relied on to justify any kind of disparity in the current wage rates. And we're going to talk about that in more detail here in a minute, because the Colorado statute is essentially a 3-pronged statute. We have this first piece, which kind of mirrors and extends the concepts of the Equal Pay Act. And then we also have 2 other portions of the statute. One focuses on wage rate history, and the other focuses on promotional opportunities. And so we'll talk about those here in just a minute. But these are kind of the general guidelines for whether or not a wage differential under the Colorado statute will be appropriate. And that was a duplicate slide. My apologies. So let's talk a little bit about this whole wage history concept. This is a bill that was actually a standalone bill for the last couple of years, generally trying to prohibit employers from asking about and considering an employee's wage history in deciding what to pay them in a current opportunity. And the whole notion, the whole logic behind this is the concept that women's wages, minority wage rates tend to be determined in part, or at least in some cases, by discriminatory decisions. And that by relying on those past wage rates, you're essentially perpetuating the discrimination, even if you have no intent to do so within your organization. So that's the theory behind prohibiting any kind of consideration of wage history. The problem, obviously, is a lot of times as employers, you want to know what people have earned in past roles. You want to know what they're accustomed to, what you might be able to pay them in this role, what they're looking for in terms of their compensation in this role. But we now have some pretty significant restrictions on your ability to do that. So you may not seek or rely on wage history. So you can't ask candidates about their wage rate history. You cannot discriminate or retaliate against an individual for failing to disclose their wage rate history. And you cannot discriminate or retaliate against an individual who is participating or associating with someone declining to give their wage rate history. I'm not real sure exactly how that would play out, but it's in there as well. And you may not take an adverse action against an employee for questioning or discussing the employee's wage rate. Now, this is not a new concept. We've actually had a law in Colorado for a number of years that prohibits employers from preventing employees discussing their wages. That's been a protection that's been in place for some time, but it's also built into the Colorado version of the Equal Pay Act as well. And then finally, you may not prohibit the disclosure of the wage rate or require an employee to sign a waiver prohibiting the disclosure of the wage rate. So that arguably could cover any kind of separation agreements if you're inclined to try to put restrictions on those discussions and separation agreements. I don't see that very often, but it may be something that comes up in a particular case. So this gets really tricky. the statute does not prevent you from necessarily having a discussion with an employee about their wage rate history, but you certainly can't be the impetus for that discussion. You can't be the one prompting that discussion, which creates problems, right? Because an employee very well may disclose this type of stuff to you voluntarily as you're having an interview, as you're having a discussion. And then you have to be very, very cautious in the questions that you ask and the amount of detail that you allow that employee to go into. And then, of course, you simply have the problem of documenting that conversation. Because we can all, I think, probably foresee a situation where an employee may become disgruntled down the road and suddenly attempts to assert that you were forcing him or her to talk about their wage rates in an interview. And that may not have been at all how the situation came up. But you also have some difficulties of proof then and exactly how that conversation did come about. So it makes those conversations fraught, frankly, from the very beginning of the process. And you may want to consider within your organization having some fairly strict standards with respect to what interviewers can and cannot discuss, even to the point of possibly shutting down an applicant with respect to those types of conversations if they come up. There's lots of ways that can be handled, but you certainly probably need to consider that within your organization as to how it makes the most sense to put some bookends around that issue and make sure that your interviewers are not inadvertently getting into a potential liability situation. So this is the third prong then of the Colorado version of the Equal Pay Act, which revolves around promotion notice and record keeping. Basically, as an employer, you are now required to use reasonable effort to announce promotions to all employees on the same day before a decision is made about a hire into that particular position. So if you have a promotion of any kind coming up, according to the terms of the statute, you are required to notify all employees and notify all of them on the same day of that promotion opportunity. And you have to do it before you've made a decision on who you're going to hire. Now, I know from the work that I was doing with the Colorado Chamber of Commerce, we made some efforts to try to get the drafters of the bill to clarify that you only have to give notice to the employees who might be eligible for that promotion or might be working in the same business unit or that type of scenario to try to limit, this broad scale notice issue. We didn't get anywhere, as you can see. So as of right now, you're required to post all promotions with all employees. Similar to the discrimination provisions, we don't know for sure how broadly that's going to be interpreted. Does that mean if you have Colorado employees and the promotions in Colorado, only Colorado employees? Can you limit it to the employees in your building? Probably not. Are you required to give notice to your employees in other states? Seems a little bit illogical, but I don't know. The statute doesn't say. Yeah.
What does promotion mean? We've got apprentices. We're a company of electricians.
Yep.
We have apprentices. We have step raises within their apprenticeship. They become licensed and journeyman. So are those types of announcements, or if it's a journeyman, you promoted to a foreman, is that
it's a good question, and it's undefined in the statute. And I think a lot of it is going to depend on what is your process for filling that position. If you have someone, for example, who's an apprentice, and if they get to a certain level, then they have the option of becoming a journeyman, and it's a progression within essentially a single job chain, I don't know if that would be considered a promotion, because you're not going to be looking at other individuals to fill that job. It's simply progression within that individual's employment. So I would feel fairly comfortable saying that in that situation, that's probably not a promotion. Certainly any situation where you're looking at multiple candidates, even within your organization or external candidates, that for sure is going to be something that you're going to have to post. So it's going to be somewhat situational, and I think you really have to look at, not only whether there's anyone else being considered for that job, but whether to an outsider, that's the kind of position that looks like you should be considering other candidates. I mean, certainly we can foresee circumstances in a business where you have a job coming open, but you have an internal candidate who's just fabulous. You really want that person to get promoted. You want that person to succeed. But if it's something where, to a third party, you should be looking at multiple candidates, that might be a situation where you would have to post. We don't know. We just don't know how it's going to play out. We're not real sure what's going to happen in terms of guidance from the Department of Labor. So I think you have to consider those types of factors in deciding whether it's something that would fall into the notice provision. So, yeah. Yes, David?
So, help me understand how this works. You have been hired into a new job at company, and I am out that has been promoted into the position of this, and her salary and benefits are X?
The statute is assuming that that's going to happen before you do the hire. Does that make sense? So,
Right, but I have to disclose information about your compensation into that position. You may believe is confidential and don't want your coworkers.
2 points. First of all, yes, you have to disclose it, and you have to, and we'll get to that in a minute, you have to disclose it before you hire.
Right.
Second of all, I think it's pretty clear under Colorado state law that compensation information, well, let me put it this way. Certainly employees aren't required to keep compensation information confidential. And certainly with the passage of this law, I think it's pretty clear that employers, in this case, have no discretion. If you have to reveal the compensation in the context of the posting, you have to reveal it. I wouldn't say that under really any legal theory, compensation information has ever really been confidential to the extent that the employee could have some sort of confidentiality right in it. And certainly, at least in this context, the law is pretty clear now that even if the employee doesn't want it revealed, you're going to have to as part of that hiring process.
You have to reveal her compensation, the job compensation.
Yep. That's right, yeah, and that's to the second bullet point. So the whole notion is when you do this posting to all of these employees, the exact scope of which we're not real sure of, you have to either apply specific salary or wage rate or a range of salaries and wage rates to that position ahead of time. And then the presumption, I think, by reading the statute is that you then have to hire somebody within that range or at that particular salary. And if you don't, there's a provision in the statute where you have to repost the position with the new salary considerations, the new wage rate considerations, and essentially do it all over again. So,
This is really very
sure.
A rate, but higher than that rate. Is that okay? Should we post the minimum of a range versus
Yeah, I don't, if you hire within a given range, I think you're fine. I would have deep concerns over, sometimes you may get a candidate and then you start negotiating, right? And you offer that candidate more than that range. I think it could be problematic. The statute doesn't address that particular scenario, but because of the reposting requirement, I think the implication is that's not something that the statute necessarily will permit. And so obviously that creates certainly new problems and new considerations. And I think you may have to consider whether you have to repost. Yeah, John.
Is there a collective bargaining exemption of any kind for employers that have contracts that require specific posting orders, or maybe bargaining with employees at first dibs and not at one point?
I don't believe there is. So do you remember? I don't think there is. I don't think there is either. I know it was an issue that came up when we were discussing the bill that there needed to be one, but I don't think there is one. So that obviously, is something new. Most laws that we have a collective bargaining exemption in these types of scenarios. So that's going to be something that's going to have to be worked into your negotiations. Good question, John. So we have the reasonable effort. We have the notice that includes the comp range and benefits and the fact that you have to redo that notice if that changes. You have to retain the job descriptions and the wage history records for a position for the length of employment plus 2 years. And so when we're talking about wage history here, we're talking about your wage history in that particular position, not the individual's wage history, because as we've learned, that is, according to the statute, not really your concern any longer. An employee has 1 year to file a written complaint to the director of the division if they believe that there's been a violation of either the record keeping or the posting. And here's something that's really interesting that garnered quite a bit of discussion when this bill was going through the legislature. There's actually an adverse inference built into the statute. So if any of you have ever had the privilege of having a discovery spoliation issue in any kind of litigation where there's been an issue over whether or not someone has destroyed evidence, we now essentially have a mini version of that adverse inference baked into the statute. So if you fail to keep the records that are required, and then you end up in litigation over that, the statute allows the judge to instruct the jury that your failure to keep the proper records was in bad faith, that your failure to keep the records means more likely than not that the records were going to be favorable to the employee, and that the jury may rely upon that to determine that you did in fact act in bad faith in not keeping those records. And that's really something that we don't see hardly at all unless we're in a spoliation type situation where someone's in active litigation destroying documents. So That's a very strange concept to have in a statute in this particular type of scenario. It's something that we discussed a lot when this was going through the legislature, because it just makes no sense. People make mistakes all the time with respect to record keeping, but it's there. The good news is the judge has discretion. It's not something that's automatic, but it certainly just adds one more hurdle and wrinkle into any kind of legal situation as an employer if you have a whole new records for whatever reason. Yeah.
I have two questions.
Sure.
One is posting something on an internal job board sufficient to say you posted it to all employees at the same time, or do you actually have to send an all employee notification?
No, the statute doesn't specify, but what I would say, logically speaking, if you have any kind of internal system that all employees have access to, and that's part of your regular process, that's going to be fine. Obviously, posting out of your ordinary practice on some out-of-the-way site to try to comply with the notice, that could possibly be a problem. But if it's a typical process that you use and all employees have access to it, I think that would be fine.
And then secondly, with regards to the, maintenance of records, I'm assuming that maintenance obligations start when the law goes into effect. It's not that historical, I'm not, you wouldn't have to have your job descriptions for an employee from 2015.
Yeah.
It's starting when.
Yeah, there's no retroactivity provision in the statute. And we haven't gotten to it yet. This starts January 1st, 2021. So we have a little bit of time. And the reason is that I think they're trying to give employers an opportunity to evaluate their organizations and their processes and make sure everything's in line before the statute becomes effective. And we'll talk a little bit more about that with respect to an audit process here in a minute. Yeah.
Of the job, and might be so versus reading over
yeah.
Now all the time more identified.
Yeah, good question. So for those on the webinar, if you didn't hear, the question was whether there were any exemptions for type of employee or type of job on the posting, and the example was the CEO, and the answer is no. That's not to say that by regulation, the department or the division may decide it makes sense to have some restrictions there. And that's part of the reason why a lot of us were discussing, can we limit this to the people who would really have a need to know, right? And no such restrictions were in the final bill. So hopefully that's something that by regulation we can get clarified, but as of right now, there's no limit. Mm-hmm.
So if you have a corporation that owns a bunch of companies, you have to notify all the different companies, even if they're under a different federal ID number?
That's a good question, and probably not. It probably just depends on which entity is doing the hiring and exactly the corporate structure and how everything comes together. So it's probably just going to depend. If you have completely separate employees, completely separate operations, there's no lap over, probably have a pretty good argument that those aren't really your employees. You can probably avoid the notice. Some vertical structures are a lot more integrated than that and share processes and HR or accounting or those types of things, and the more of those types of scenarios you get, the weaker your argument that there's a distinction. So we don't know. I think it's something to keep in mind and to be cautious about if you're in that type of organization, and so we get more clarity. Yeah.
Do your public job postings for openings now have to include all those compensation rates? And do you have to publicly post all those openings?
Yeah, no, there's no provision in the statute that applies this to all of your advertisements or all of your postings, but it just makes clear that you have to have a posting to all employees that has that information in it.
Just that internal
posting. Yeah. Yep.
Okay.
Good. So with respect to the record keeping violations, there's a penalty built into the statute, $500 to $1,000 per violation. And those violations really probably could mean something as simple as a single sheet of paper that doesn't get kept properly. So obviously you want to avoid those. It's also something that's not likely to come up unless you're audited for some reason or there's actually litigation down the road, but obviously you want to be very diligent about your record keeping from the get-go. So under the Colorado statute, there is a private right of action, civil action available. There's a 2-year statute of limitations, a 3-year limit on recovery. So at least we're not facing the old Lilly Ledbetter situation where you can go back for decades. You can recover for 3 years. Remember that a charge under the Colorado Anti-Discrimination Act is still available because just like under federal law, The Colorado Anti-Discrimination Act also prohibits discrimination in the terms and conditions of employment based on sex. So just like under federal law, you have essentially a dual liability issue here, one under the Equal Pay Act, one under CADA. Under the Colorado law, we have, again, these are FLSA type damages because they're patterned in part on what the federal statute allows. So economic damages, liquidated damages with a good faith defense. We'll talk about that more here on the next slide. But essentially, the way the statute is written, if you can prove that your error was in good faith, you can get out of the liquidated damages. Okay? And the audit is a specific defense that's built into the statute for establishing good faith, and we'll talk about that here in just a second. And then legal and equitable remedies for the violation of the wage rate prohibitions or the record-keeping requirements. So again, we don't have any punitive damages, we don't have any compensatory damages under the statute. Those would be available under CADA now, because the CADA damages essentially mirror the federal damages that would be available under Title VII, the ADA, ADEA, and the like. So have that same dual statute or multiple statute issue that we have under the federal law. So with respect to, go back to the EPA for a minute, the federal law, with respect to Title VII, and to some extent I think this probably also applies to the Colorado statute, there's some differences, and we don't tend to see a ton, I don't tend to see a ton of Equal Pay Act claims. I've seen a few over my career. Far more Title VII claims, right, or ADEA claims or ADA claims with respect to compensation discrimination than EPA. And so then it begs the question, why? Why are you likely to see one claim over another? What are the differences? We've already talked about damages. That's one obvious difference. But some of the other differences. So with respect to the Equal Pay Act, there's no charge filing requirement under the Equal Pay Act or under the Colorado law. You can, but you don't have to. So it's faster, right? A lot of plaintiffs don't want to spend, 2 years waiting for the ESC to get around to investigating their case, and you could just move straight ahead with a civil action. Title VII has better remedies, right? It has the compensatories that are available, the punitives that are available. Emotional distress is a huge component of most discrimination claims. And so if you've got compensation discrimination, that's a huge component that's available under Title VII or CADA. This wouldn't necessarily be available under the EPA or the state version of the EPA, especially in a situation where you may not have a lot of economic damage. You might get a case where you have a relatively short-term employee and the economic damages that he or she might recover are small in a legal action. In that case, things like emotional distress become a lot more important. And so you may see a claim brought more under Title VII or under CADA than you would under the EPA in that type of situation. Also, with respect to burden of proof. So you may be familiar or not, hopefully, if you've never been in that situation. Under the discrimination laws, there's burden shifting, right? The employee has to prove certain things, and then the employer has to produce a non-discriminatory reason for the action, and the burden shifts back to the employee. With respect to the Equal Pay Act, it is incumbent upon the employer to prove the reason for any kind of wage disparity. So you have the burden of persuasion, persuading the judge, persuading the jury as to why there's a wage differential and why it's appropriate under the law. So that holds some allure to a plaintiff because that becomes your responsibility and not the employee's responsibility. Okay? So there's differences, there's distinctions. Keep them in mind. They could be important if you have an allegation, if you have a charge, pay attention to what they're alleging because it may affect the damages and it may affect litigation strategies if you're dealing with an emotional distress claim or you're not dealing with an emotional distress claim, even if you're dealing essentially with the same conduct, which is compensation discrimination or an allegation of compensation discrimination. So let's talk for a minute about audits. As I mentioned a minute ago, there is a good faith defense built into the Colorado statute if you have conducted a recent audit and corrected any kinds of issues that came out as a result of that audit. So that's good, right? I mean, that gives you some control over your organization. Having a good faith defense is really important and certainly gets you out of liquidated damages, which can cut damages by half out of the chute. But audits, are tricky and they're fraught and they take a lot of time and you have to be very careful with them. So let's talk about some of kind of the do's and the don'ts and the best practices for audits if you decide to do that. use an attorney out of the chute, right, with respect to the audit. Try to keep it privileged as much as possible. You can always waive that privilege later if you think you need to. If you need to use it as a good faith defense, obviously you're going to be waiving a substantial amount of the privilege attached to an audit. But initially, while you're doing this as an internal process, have either in-house counsel or an outside vendor or counsel guide that audit, right? So that way you can keep it privileged and you can have privileged discussions about what to do about any findings that you get. Be prepared to fix any disparities. If you have an audit, you need to be willing to do what you need to do to address any problems that that audit uncovers. For a lot of reasons. One of the first important reasons is you then have for sure knowledge of a problem if you have an audit and it uncovers something. And then if you have legal difficulties later, you suddenly have knowledge of a problem that you didn't correct. And that's just not a good situation to be in. So you may find minor things that need to fix. You may find something really big that needs to be addressed. And you need to be prepared to take steps to address that, even though it's somewhat of a mystery what that might be at the beginning. You need to go into an audit with your eyes wide open that you may have something that causes, substantial financial burden to correct, or time, or employee communication issues, or all types of things. So be prepared for that going into an audit. And then finally, especially in the wake of the new Colorado law, which does not have that catch-all, any factor other than sex, you really need to start paying a lot of attention to your wage decisions, what goes into those decisions, focus on the specific factors in the statute, use those criteria as your justification for your wage decisions, make good documentation of them, because, unfortunately, if you end up in a legal situation, you're going to have to be able to have that backup documentation that ties directly to the language of the statute. So now is the time. We've got, a year and a half until the statute becomes effective. Now is the time to really look at your internal processes. Can you apply the statutory factors to the decisions that have already been made? Do you need to do kind of an overhaul review of everything to get those factors in line with your compensation structure? All those types of things, and now's the time to do that because we have a little bit of time to do it to get everything ready to go by 2021. Okay. So thank you for being here. I'm happy to take questions. We have a few minutes left. I'm happy to stay after as well. So enjoy your day. Oh, okay. Sheesh. Do you want me to do these first, or does it matter? How about you guys first? Do you have any questions here? Okay, in the back.
On the description on possible documents, does that also apply to things like a government agreement or are those still okay?
So prior to the passage of this statute, really what the statute that existed said that you cannot prohibit employees from discussing amongst one another their compensation. And that's not really all that different from what the NLRA would require with respect to, good faith discussions about employment conditions and the like. But we saw more of those types of restrictions prior to the statute. I think the way the statute reads, including there was the one provision that you cannot have any kind of waiver of the right to discuss wages. I think it's probably at your own peril to have those kind of restrictions, even in a separation agreement where they're fairly common. Okay.
With regard to wage discussing wage increase, you use that in consideration of an internal promotion, their current wage. If you're still hiring within a range that you've established,
yeah.
You expect that, X%, at least X%.
Yeah, there's nothing in the statute that would prohibit those kinds of conversations internally. It's soliciting the information from an employee where you don't already have it. And you can't use, even if you had it from another source, you couldn't use it in a new hire. But there's nothing that I think in the statute that would prohibit you from doing that kind of internal analysis. Is there a question over here?
Yeah. In interviewing new candidates, we want to make sure that we're on the same page for salary expectations. So we revised our question to ask instead of in history, what are your salary expectations?
Out of the chute, that doesn't violate the statute. The problem is where the conversation goes after that, right? Safer way is maybe along the lines of, this is what we're offering for this position.
Yeah.
Is that something you're able to, kind of like you do with disability, right? Is that something that you're able to accept?
Right.
But then even with that kind of prompt, you have to be really careful with where the conversation goes after that and make sure that the employee is the one that's revealing any kind of wage history information.
Right.
Yeah.
Just a quick note on that. It's not just asking for the information, it's relying on it.
Yep.
So your first question,
to Bert's point, totally fine, but then if they give you information, if you rely on what they're giving you, it's gonna be a battle down the road over, like, who said what, why did you say it, how did you come to the conclusion that you did about the salary that you said?
Right.
That's why Bert suggested flipping it on its head, because it's not just the question, it's what you do with the information that you're given, whether you ask for it or not.
Yes.
So I think practically the statute does two things. Number one, I think it pushes employers to having fewer of those discussions and more just, this is what we're paying, yes or no, take it or leave it, which has its issues, obviously.
Yeah.
And then second, I think to the extent any of those conversations happen, pushing wages up, pushing the final decision higher in the wage scale, to avoid any notion that you're depressing somebody's starting pay because of information you got during those interviews. And it's going to be, I mean, it's all over the place, right? I mean, the spectrum is huge in terms of how those conversations can go. But I think that's a couple of practical implications of the statute. David?
So you would counsel against the historically question, you have salary expectations. Employees says, well, I'm making X at my current job and doing transportation.
I don't know that I would counsel against it, absolutely. What I would say is that you've got to be prepared for what happens after you ask that question. I think the statute's pretty clear. It doesn't prohibit a conversation about it as long as the employee is the one revealing all that information. But that's a slippery slope really quick, right? And if you have any kind of substantive discussion about it after the employee reveals the information, I think you've got some potential risk there. So I think you have to understand the risk and the perils of having those conversations. Obviously, there's very strong business reasons for having those kinds of conversations, and you just have to balance that with understanding that, you know, those are the kinds of things that get flipped on their head if there's ever a legal dispute with an employee down the road.
Second question, different topic, talk about looking at the organization as established both geographic locations. On the other hand, geography can be a business justification for pay disparities. Wage rates, for example, in California are probably higher than in Colorado.
Mm-hmm.
So looking at an establishment that tends to obscure a pay differential in Colorado if you're having to consider the California data. So how do you sort all that?
Could you repeat the question?
Yeah, so basically David's question is if you've got employees that are in Colorado and you have employees in other jurisdictions, there's different minimum wage rates, there's different wage standards in different states. How do you deal with that and the concept of, you know, who do you have to look at, who do you have to compare, and how do you account for those in determining whether or not you have an impermissible wage disparity? And I think my advice would be you just have to be very deliberate and specific in identifying what the factors are that distinguish your Colorado employees in that job from your California employees. I mean, if it's minimum wage, we all know California, Washington, Massachusetts, places like that are going to be higher. And if it's strictly a function of statutory minimum wage, that's easy, right? Do you have any internal organizational factors that are also driving those wages? Some of it may be standard of living, which is going to be higher in California. I think that's probably a very permissible reason. But there may be other reasons that are less, law-based, less economic-based, and I think you just have to try to do the best you can to specifically identify what it is that's causing the disparity so that you can determine with your best faith efforts whether it's something that would be permissible or whether it's something that you need to look at from an organizational perspective.
You shouldn't be able to rely on the out-of-state data in order to justify an in-state disparity.
I think it depends on what that data is. Yeah. I mean, if it's, like I said, if you're paying an employee at minimum wage, your California employees are going to be making more than your Colorado employees, and I think that's fine. But it's over and above that, right? If it's something less clear than that, that's where you're going to have to start using your discretion and get as much specificity as you can in terms of what you're relying on. Any other questions in the room? And then I'll try to, yeah.
I have a question earlier. The transparency of the salary range, whatever that is, and some like maybe defined internally what we consider salary range. Is that requirement is only for internal posting and not also for external posting?
There is no requirement in the statute that you include that information in public postings about the job or in every posting about the job. It's simply a requirement that you have a posting that goes to all of your employees somehow, somewhere, that contains that information.
And we define what the range is, so 1 0 to $1 million at their range.
That's one of those, we've talked about that internally, that's one of those unsolved questions, right? There's nothing in the statute that prevents you from doing that. If employers start doing that, the division will do something about that sooner than later. So, you know, I think obviously be broader, right, if you need some discretion, but also keep in mind if, you know, if you do something that's crazy, it's likely to draw attention and probably won't last, so. Yeah. Mm-hmm.
Are you required to post externally?
No, you're not required to post externally. Mm-hmm. Yeah. Well, yeah, I'll take that back, yeah. Nothing by this statute obviously requires you to do that. Okay, yeah. Okay, let me see if I can get to these. So for a question from the webinar, does the attorney need to be outside counsel or can an internal attorney assist and keep privilege? I assume that means audits. You certainly can run it through your in-house legal counsel if you want to, and a lot of times you do. Sometimes with audits, it's maybe helpful to get an outside attorney who may have more specific audit experience. Probably depends on the context of your internal counsel. And then down the road, obviously, you have to consider too, you know, internal counsel gives advice on all different kinds of things, and there could be conflicts that pop up down the road. So consider carefully what you do. There's no specific prohibition on your internal counsel being the one guiding the audit, but sometimes there can be more credibility if it's run through an outside counsel if you ever have to waive the privilege and use it as a defense. So those are all the different types of things you can consider with respect to that. With regard to the salary posting, should we post a very broad range or a minimum range? That was a question raised just a minute ago. Pros and cons either way. I think broader probably gives you more leeway in, you know, setting a salary or a wage that's appropriate for your particular candidate, but obviously ranges that are too broad could cause problems down the road. Does the announcement of promotions have to be all employees if they're in a different state, or can you notify Colorado employees? We don't know. Because there's no establishment restriction in the Colorado law, as we've talked about, I think you have to consider whether you have to consider outside employees, and we're not going to know for sure until we get some regulatory guidance or at least some court decisions or both on how that plays out. How detailed does the benefit information have to be? Does it mean insurance plan design, or can it be more generic like medical, dental, life, and 401k? With respect to the posting, you're required to post benefits as well as the actual wage rate or salary. I don't think it has to be more specific than categories. There's certainly nothing in the statute that says it has to be more specific than you know, categories of benefits that are available. So I think, you know, medical insurance, health insurance, vision insurance, you can always add the, you know, in accordance with our existing plans, that kind of language in your posting. Do you have to include variable pay such as bonus eligibility or just base pay? If you have bonuses or other types of compensation built into that position, you have to post them by category as well. Do we have a definition of promotion? I think that kind of goes to a question the gentleman asked a little while ago. We don't. Again, I think you just have to look at your specific situation, and if you've got, you know, multiple people that would be eligible for the position, that's probably a promotion out of the chute. If it's something that's just a job progression type situation, maybe not. But make sure you pause and look real hard at your situation and consider whether you've got any issues there. Can you ask how much do you want for a wage salary? I think we had that question as well. Yeah, you can ask that question. It's just a matter of where the conversation goes after. For Colorado and federal, what is considered a wage difference that is substantial enough to trigger the statutes? It doesn't matter how substantial it is. If it's a disparity, it's a disparity. There's no de minimis threshold or materiality threshold. If it's a differential, it's a differential. Is it possible to determine a difference in pay for the same position based on the cost of living in different areas of Colorado? For example, can there be a pay differential for the same job, one in Denver and Grand Junction? We had some questions that touched on that. I think probably you're going to want to have good data to back it up, and something more than just your, you know, gut feeling that there's going to be a wage differential between the Front Range and the Western Slope, for example. You're going to want some data to back that up. But yes, I think you can have that kind of scenario. And if there is a violation that would constitute a violation under federal law and the new Colorado law, could back pay and or liquidated damages be doubled, once for fed and once for state? Generally not. You can recover categories of damages once. So you can, you know, get your back pay once, you can get your liquidated damages once. Now you can have, again, a claim under two different statutes, right? You can have Title VII and the Equal Pay Act, for example. You get your back pay once, you get your liquidated damages once, but then you could also get compensatory and punitives under the other statute. So you can't double a certain category, but you can have multiple categories coming from different statutes, if that makes sense. Okay, any other questions here? Yes?
For a minute, we talked about posting the range of well as the fulfillment. What about like restricted stock? Is that like not a definite or part of an annual process, but a likely?
You know, it's hard to, as a category, I think if it's built into the job, yes. If it's something that gets negotiated, that's where it gets really, really difficult because we have that reposting requirement, but it doesn't go into any more detail with respect to negotiations. So it's hard to say. You might do a range. I think the easiest thing to do if it fits within your organization is to say, you know, bonus eligibility or possibility of restricted stock or something like that, which might give you some leeway to decide yes or to decide no without having the reposting issue. Of course, there could be, you know, just practical issues with having maybes in your job postings, but that's probably the easiest way of getting out of the reposting issue if you can manage it from a communication and employee, you know, negotiation standpoint. Yeah.
We have both an Inc. and an LLC. We have 5 employees at Inc. and the rest are employees are all LLC employees. If we are looking, and those 5 employees at Inc. are any of them, so CEO, CFO, GC. If we have to post one of those jobs, do we have to post all of those job openings to LLC employees, or can we only post them to Inc. employees?
Yeah, and that is complicated based on whether you've got any kind of joint employer kind of situation associated. Statute obviously does not go into that much detail. I think if there's any possibility that you'd be considered joint employers, if you share, you know, if that's the CEO over everybody within the LLC, that's probably a situation where the safest thing to do would be to post. Now, there's a lot of gray area or simply vacant space with this statute, so you know, for a while you may have some leeway to play with those kinds of things, but just judging on how I think the state's going to look at these things down the road if they come up, the closer connected those two are, the more likely they are going to find a posting requirement. Does that make sense? Anything else? Thank you very much for being here. Enjoy the rest of your day.